Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law, estate planning, and probate attorney in New York. Today is day 4 of the probate primer. But first, before I speak about that, I'd like to let you know if you want to reach out to me, if you need to reach out to me, please go to callfrankbruno.com. I accept telephone calls and in-person interviews. Today I want to discuss in Probate Primer 4, contesting a will. So I'll give some information about that. When we last left our story, we had submitted paperwork to the court, and I said I would let you know if there was going to be a bumpy ride, how that goes. Well, the executor in our story, the executor filed a will with the court. And we're waiting for the court to determine that the will is valid. Just because a will is filed doesn't mean that it's valid. We want the court to look at the documentation that we submitted and confirm that it's valid, and then to appoint the executor, and then the executor can go on to stage 2 and stage 3 of the probate process. So while we're waiting for the court to decide, a person with standing can object to the will. So they could do that 2 ways. They could, give the executor a little bit of, or the proposed executor, a little bit of a hard time and not sign a consent. If they don't sign a consent, it sort of throws the probate into a contested posture, because then the proposed executor has to file a citation and secure a court date, right? So the burden shifts to the potential objector to say, hey, the will is invalid for this reason. So the person needs standing. They need to have been either an heir at law, or a beneficiary of the will, or a prior beneficiary. Say there was a will from a few years ago that left them a percentage of the estate or a house or something, and in the most recent will, that person was written out of the will. So that person would also have standing. So you need to have standing to object. You have to demonstrate what it is. And usually there's one of three grounds. One could be that you're alleging that the person didn't have mental capacity to sign the will. Another valid reason to object to a will could be that the will was not properly executed. So the will didn't conform to the requirements at law. There's a third reason. It escapes me now. We have incapacity, that the will wasn't properly signed, and oh boy, I forgot the third reason. I'll give you the third reason next time, and that'll give you a reason to come back to see me. So if you'd like to speak to me about things that I do know, please go to Call Frank Bruno and make an appointment. Thank you.